Welcome to the first episode of what I think is going to be a really important conversation for anyone involved in Nigerian businesses. Whether you're running a company, lending to one, advising one, or investing in one. Today, I am here with Amala, a partner in the turnaround and restructuring practice at Stren & Blanc Partners, who has been at the core face of some of the most important turnaround transactions in the market. Amala, welcome.
Thank you very much, Umeike. Thank you. Happy to be here to speak on a very important topic, but I think something that's quite overlooked, around. Thank you very much for having me.
Thank you. So we'll be setting the stage, and most of the conversations we'll be having today will be around corporate restructuring in Nigeria, where we are right now and where we are heading. But before we get into it, I want you to give us a sense of why this conversation matters right now. Why should a CEO, a CFO, or a lender be paying attention to restructuring?
Okay. So think of a company as a human being, for instance, right? Somebody is born, and then at the end of the day, the person grows, gets sick from time to time. Now, how do you get sick? You can get sick as a result of your behavior, for instance. You can get sick out of things that are outside your control. There might be a flu, right? So if you think of that in that sense, you would see that a company is actually can be seen as a human being, isn't it? So a company that's been incorporated and that's been born, right, would go through phases, will go through things that are not within its power sometimes, and things that are also within its power. So to go through certain macroeconomic turbulence, currency fluctuations, things that even itself can't control, right? It will also go through things that probably would also be able to control, cost-related issues, corporate governance issues, malfeasance from whether it's directors or people around it. So whatever it is, right, it's important that we have this conversation because things can happen. Things are happening. The economy can go through turbulence. The economy, one can say, depending on your perspective, is going through some, not just Nigeria, but across Africa, globally, the tariffs and stuff like that. So it's important that CFOs, CEOs, C-suites generally, and anybody who is actually doing business, and not just anybody who is doing business in terms of the company itself, but also trade partners, for instance, lenders, for instance, creditors, for instance, even employees understand some of the issues around corporate restructuring so that when it happens, when the company gets sick, you do understand the various options open to the company. You do understand some of the steps that you can take in order to bring that back company into a state of good health, so to speak. And even when it's inevitable, right, when you probably have to then exit, you understand the sort of rights and duties and powers that are there and the options that you can take,
Because of course, when you see or hear people talk about restructuring, they always think about something negative. Job losses, company closures. How can we walk around that perspective?
Well, that's what we're trying to do, isn't it? By sitting down to try and educate people. There's this perception, obviously, that when a company is going through restructuring, or it's already a dead company and issues that are scrambling and all that. That's not it. So if you look at it from the perspective of the fact that a company is sick, just like a human being, if somebody is going to a hospital, does it mean that that person is dead already, or that the person is going to die? It might be a quick fix. It might be a long fix. It might be that, the company would probably need to be sold as a going concern. But the idea behind all those things is that there are more sensible ways of doing these things, right? And that is what corporate restructuring does. It gives you the best outcome for the company. It gives you the best outcome for the creditors. It gives you the best outcome for the society. It gives you the best outcome for the employees, and everybody is well off for it.
So in essence, should we call this series a masterclass? on how to navigate corporate distress.
Essentially, what we're trying to do with this, hopefully the first of, the many more, but what we're going to try and do would be to go through the anatomy of a company, right? Various issues and look at it and hopefully be able to diagnose some of the issues and look at how one would be able to navigate around them.
Okay. So for the sake of our listeners, let's start with the fundamentals. When we say corporate restructuring, what exactly are we talking about?
So I think I've made the point. Corporate restructuring is essentially a process of trying to better the situation of a company. I'm trying to put it, because we have a diverse audience, right? It's just a process of trying to look at a situation. Obviously, before you talk about restructuring in the sense that we're looking at it, a company would have gone into some murky waters, right? So when you talk about corporate restructuring, it's that art of, and it's not just a legal process, and we'll look at it. It's the art of trying to better. That's the simple way of looking at it. It's the art of trying to get things better for a company. Whatever that process is that you would follow in order to get the best outcome is actually what you do when you look at when you embark on corporate restructuring.
Okay, great. So I've had a couple of conversations with people, and they always say that restructuring can take place, in a reactive model and also a proactive model. Reactive in the sense that these companies act when they're already in trouble, and these companies also act when they perceive the early warning signs. So how can we, find a balance between both options?
Firstly, I think you have to look at it from a particular context. You're quite right. You can look at restructuring from two angles, right? And therein lies also issues relating to insolvency, enforcement, and all that. So if a company is looking at trying to ensure that it stays competitive in the market, for instance, then it can embark on some restructuring exercise. Not necessarily, and that's proactive, right? Not necessarily that it is going through a problem, right? But when you look at it perhaps from a reactive perspective, that would typically have been when the company has gone into some level of, difficulty, and then you are trying to then remedy what the problem is. There are obviously tools around these things, right?
Okay. So I want to know, people usually use both terms interchangeably. You get turnaround and you get restructuring. But is there any difference between both, or they are quite similar?
Well, I say I'm a turnaround and restructuring lawyer. And honestly, if you look at it in a sense, it's not as if there is a big difference. However, turnaround is broader, right? It has to do with everything that would get the company to get to where you want it to be, But in a sense, restructuring can be narrower if you look at it, right? So I wouldn't want to dwell on the point as to the distinction between, because to me, they're all the same, right? But there are theories around the fact that, turnaround has to do with broader sense of things, why restructuring is a bit narrower. For me, personally, it really doesn't make any difference, right? The idea at the end of the day is that you want to get the best outcome for the company, you want to get the best outcome for the society, you want to get the best outcome for, creditors, lenders, and all that.
Okay. So let's bring this down to the Nigerian context. Where are we in Nigeria in terms of our legal frameworks for restructuring?
So prior to 2020, and that's still the problem we have in the market, especially from a legal perspective, we had the Companies and Allied Matters Act, and that was done in 1990. Now, that law actually had a that's how I would put it, a pro-liquidation philosophy, right? So a company is distressed. Company is not able to pay its debt. Kill the company, liquidate the company, distribute the assets. That's essentially what you would typically found. Obviously, you had the concept of receivership under that law, But the concept of receivership, if you understand it, and for me, I always say that my theory is that the receivership, except in very narrow bilateral circumstances, is antiquated. We borrowed it from England, right? And in England, what they call administrative receivership has actually fizzled out. It's been abolished under the Insolvency Act, Enterprise Act, and so on. And so receivership, if you understand the concept, is where you are appointed to act on behalf of a certain creditor, and you have a sole mandate, which is to realize assets, go in, take over assets, realize assets. And when I mean realize assets, do a fire sale, and you pay off the creditor. That might work in a situation where you have bilateral relations. You know, you have one creditor, and then you have the company and all that. But in large mandates, which is sort of thing that we like to work on, you will find that there are multiple creditors. And so it becomes a problem, you know, intercreditor fights and all that. So in 2020, a new Companies and Analyzed Matters Act was done. And that goes to your question as to where we are. So where we are now is that we have the CAMA 2020. Luckily, I worked on the committee that did the insolvency part of it. We worked in conjunction with World Bank then. And thereafter, you had the Business Facilitation Act. And then you have the insolvency regulation, which provides some sort of subsidiary legislation framework. It was done in 2022. Luckily, again, I chaired a committee trying to set up by the Corporate Affairs Commission, which is the Nigerian Companies House, trying to improve on the law as it relates to insolvency at the moment. Because, you know, the realization, and I will talk about it, is that good business framework, especially from a legal perspective, has to be founded on a robust restructuring insolvency framework. Now, where we are now, remember I said prior to 2020, we had a pro-death, let me put it that way, a pro-corporate death standpoint, right? Or a pro-corporate death philosophy. That has changed, at least in theory, by way of legal framework, by the enactment of CAMA 2020. Now, what CAMA 2020 did was to provide the framework, perhaps for the first time in Nigeria, where companies can then embark on corporate restructuring through and through. It introduced CVAs, it introduced administration, which to me is a very powerful tool. In fact, it's just a window, it's an opportunity. It allows the company, whether it's from a creditor's perspective or from the company's perspective, to go into a process of an orderly rescue and obviously, getting the best outcome for both the companies, for the creditors, in a manner that enhances value, not just for the company, and that's very important, but even for the creditors. Because, when you go in as a receiver, more often than not, you sell sell the assets at 30 cents on the dollar, 40 cents on the dollar, because you are doing a fire sale. The person that is buying it will tell you, oh, it's a property that is likely going into this place. Exactly. And they're buying it at $30, $40 to a cent, right? But, I'll come to that. Even when on that a restructuring process, you believe that the best thing is to sell the business you are selling it as a going concern. You are able to remedy the issues, package the company very well for you to be able. In fact, in England, where they do pre-packs, that's actually, the norm. And so you are suddenly able to extract more value for the creditors. You're able to extract more value for the employees, for the society, for the company itself, right? So everybody is better for it. So where we are now is that we now have this framework. Where we are going is what we're doing now, Omi and you were doing, which is to try and create that, because the truth of the matter is that people really don't know. There's a resistance. We practice turnaround and restructuring. There's a fierce resistance by the companies, by even creditors, surprisingly, right? We're currently handling a high-value restructuring for a large real estate concern. And, for the first time, maybe not for the first time, but at least I'm being confronted openly by creditors, and you ask yourself. So, and it stems from just lack of understanding, lack of knowledge. Sounds so alien. So, But hopefully we're going to that point where the market embraces, what is happening generally globally, the norm. When you look at the Chapter 11 bankruptcy procedure in the US, look at the administration framework in the UK, for instance, we're going to that point where corporate restructuring becomes enough, right? It becomes the preferred tool for everybody who is involved in a special situations or in a, working with a distressed company scenario.
Okay, so now that we've heard about, CVAs and administration, liquidation, receivership, let's bring some practicality to this conversation. What actually happens in practice when a Nigerian company hits financial hardship?
It depends. Let me put it that way, right? I tell you from my experience, when a company hits financial distress, there's that tendency for the company to try and hide it. They don't want to talk about it. They believe it's a stigma, right? For them to seek help. So they try and, in fact, in reality, in practice, what people do, they try and borrow more money. They try and get more money, Oh, don't worry, what we need is an additional line of credit and we'll be fine. So it's like when somebody has a terminal disease or, a problem, right? That's one disease that comes to my mind, but I'm not sure I should say it. But people then, rather than seek help, right? You try and hide it, right? So that's more often than not, that's what you see happens, right? And typically, obviously, at some point, it gets out of hands, then the creditors know about it, and the next thing they do is to try and enforce, especially when you have multiple creditors. Each person is scrambling to go to court, get this order, go and freeze the account, go and, close down the company. It's madness.
But in practice, right, we've seen situations whereby, of course, we have to publish notice of administration, newspapers, Federal Gazette, and you see where people pull out. Partners pull out, right? They don't want to do business anymore with these distressed companies because, of course, there is needs of administration in the block. Now, in my opinion, can we say that this fear is justified? This company is trying to hide the fact that they are now currently under administration or now they are now distressed. Can we say that their fear is justified in a way?
I do see your point, right? Which is that, if they go into this process, right, then the company.
No business deals.
Yeah, I don't understand. And that's obviously, I'm careful to say it's justified. I'm careful not to say it's justified. But the point there is that, and that's why the education needs to go around, right? Not just on the part of the company, but generally speaking, on the part of the society, on the part of the trade partners, on the part of the creditors, to understand that when these restructuring processes start, especially the formal ones like administration, it doesn't signal the debt. So as a firm, for instance, because we are pioneering some of these restructures, especially when it comes to administration, we now make it clear in the notice that, look, it doesn't mean that this company is dead or that it is, it's not going to be rescued, that this is just a transformation process. We try and make it clear to people. And hopefully, when people listen to us on this podcast or even read some of these notices, they're able to get a sense that, look, it's not so much about the fact that this company is going under, but that, it's a transformation process, a rescue process.
So let's talk about timing. Are Nigerian companies, to you, are they acting or are they taking steps relatively too late? Yes. Or they are not acting at all? Because I know that from the conversations we've had, I've noted, your hint about timely intervention. So what is that one thing that you think they are not doing?
So obviously it's the fact that, like I said, they're hiding it. And, by the time you can't actually restructure a dead company. I kid you not. I'm not saying that there's no place for liquidation. Again, if a business is no longer a going concern, if the business is dead, like I said, the point is that there is that perceived stigma around telling people that, you need help or about seeking help, right? And that's unlike other climes, and we'll probably look at it, US and all that. There's that thing about, and the point that you've made, it's quite germane, which is if people get to know, there will be panic. And it comes from the fact that there isn't that awareness and that education as to the fact that you can't stigmatize this process, right? It's a process that is there to assist you guys. It's a process that is there to assist the companies, assist you as a creditor, assist everybody. So you shouldn't stigmatize it. I do understand from a practical point why companies do that, right? But I think people shouldn't. Because if you hide it, then you then enter problems and then you get worse off for it, right? When the creditors then come and react the way the typical pre-2020 creditor would do, which is to go in, appoint a receiver manager or try and liquidate your company or freeze your asset, then you become worse off for it.
Okay. Now let's talk about the advisory landscape. When a company observes, some form of distress, rather than borrowing before creditors start walking out the door, instituting actions, who should the company call? What should be their first point of resort?
You're talking about the companies, right? So obviously a turnaround and restructuring practitioner, right? That's the first person that you should speak to say, look, I've got this problem, right? It's the turnaround and restructuring practitioner, both from a legal standpoint, both from a financial advisory standpoint, that would sit down and then look at your books, right? Conduct an independent business review, be able to provide you with not just from a financial advisory perspective, because obviously I'm a lawyer. We don't do financial advisory side. We obviously work with turnaround and restructuring experts from a financial advisory perspective, but it's important that you also understand your rights, your obligations from a legal perspective. Because like I said, administration, for instance, which is to my mind, the king of all the restructuring tools, gives you things like moratorium that allows you to have a breathing space in order to then restructure. So the point there is for companies, right, you then need to talk to your turnaround and restructuring practitioners in order to be able to get not just the information that you need in order to act timeously, in order to find out where the problem is and fix what the issues are, but also from a legal standpoint, you need to understand what are my rights, what are my obligations, how do I use the existing legal framework in order to be able to protect myself, protect the company, protect the jobs, protect the society, from a scramble on the assets and from the company being killed.
Okay, now we looked at the company perspective. Now let's look at the creditor's perspective. So for instance, a company or a creditor is being owed, right? And the company is already in default. So who should the creditor call?
Again, the turnaround and restructuring advice. I'm not saying that because I want, there's this thing, okay, look at it. You are being owed, you're a lender or you're a trade partner. Let's even leave creditors, because sometimes banks, for instance, they might have secured security, fixed assets. And let's even look at unsecured creditors. You're a trade partner, you've supplied diesel to a telecoms company to run their mass, and then the company is going through distress and you have not been fired. Who do you talk to? That's the point. Now, the typical, what's happening or what the norm is you go and talk to your lawyer, you go to court, you spend 5, 10, 15, 20 years chasing the debt. It then affects your company. Okay, leave it. Let's go to banks, right? You appoint a receiver, right? That's even the best case scenario. Obviously, let's say you haven't appointed or you don't have the powers to do that. You go and start instituting actions, freeze accounts, do all sorts of things. You end up in court for years. You're going to appoint a receiver, especially where you have other creditors. There's a scramble on the assets.
True.
And then, like we have said earlier, right, it's in various circumstances. And that's not because people don't, it's also because of the lack of skill sets, right? So a receiver manager is just to go in and force.
Mandate.
You don't have those tools, those skills that's needed in order to be able to turn around the company as a going concern in order to maximize value. So you go in, you appoint those persons, they come in, and then a property worth X amount of money, right? Or an asset worth X amount of money, equipment, a rig, whatever it is, a ship, you go in, it's sold at an undervalue. Who is to lose. Let's even say you don't want to sympathize with the company because, the employees are all sacked, the company goes down. But you as the creditor, you're getting 50 cents on a dollar. You're getting less than what you should ordinarily get. Whereas there might be a scenario where the business is managed, even if you say, oh, you don't want to stay in for a long time, there's so many deals you can securitize the receivables that you're going to get. You can sell the company as a going concern and you maximize value. In fact, there are scenarios where you probably make way more money. Not just that you would have been paid, you make more money because there are scenarios where it might be, okay, you know what, let's give an incentive, let's give an additional 0.5 basis point, 500 basis points or whatever it is, right, to incentivize the fact that you are going to be in this with us. So at the end of the day, you find out that, and this is not Amala Umeike trying to postulate, right? If you go to the first research that was done by, Sir Coke in the UK, which birthed this movement in England and what we have in Nigeria, you would see that the theory is there, the statistics are there that supports this particular postulation. So, and I'm confident that in the next 5-10 years, people will begin to realize the fact that this is the way to go. So, to answer your question, whether you're a company, whether you're a creditor, the first person you want to talk to is your turnaround and restructuring advisor. You want to talk to the people who you can appoint as administrators to go in, because they would also have the information. When they go in, there are things that the company is supposed to give to them, statement of affairs. They would be able to use this to provide at least that information that you need in order to be able to make a decision at the end of the day. So at the end of the day, whether you're a creditor or whether you're a company, you're better off somehow.
Amala, thank you for giving us this multidisciplinary approach, right? So we have the operational advisor, the legal advisors, and the financial advisor. But in assembling this team, are there things that a company is supposed to look out for in selecting their advisor? Should it be track records? What are the factors that we need to consider?
Well, Nigeria, honestly, we don't have, I don't want to say this so that I don't cause controversy, but we perhaps don't have this. And it's not our fault. It's just because, the law is just developing, right? We don't have that sort of market, right? There where you have deep expertise for now. Obviously, it's growing. We're one of the pioneers in the market doing this. So what I think they would have to look out for would be people who have the right training, who have had the experience within this period in order to be able to get the right things, because it also comes from experience. How do you manage stakeholders around all these things?
Okay, so let's zoom out a bit from the Nigerian context. So I want to know, how does the Nigerian framework compare, internationally to what's obtainable in other jurisdictions?
It's like comparing a child with an adult, isn't it? Right? Obviously, there are more matured clients, US, UK, South Africa, for instance. So there are some persons who would say that the gold standard when it comes to restructuring in the US, right? So you have, it's debtor-friendly. That's under the Chapter 11 bankruptcy. It's actually debtor in possession, right? There's a very robust market for that, supporting the entire ecosystem. I was watching CNN the other day, and there was an analysis that was being done, I think, on Quest. And they were talking about a big retail company that had filed for Chapter 11 bankruptcy. And, the idea was that maybe they wanted to renegotiate some of their expensive leases, right? So the US has a very matured restructuring framework. The UK, obviously, which is where we borrowed some of the amendments I don't want to use the word borrowed. I mean, for me, there's nothing wrong in trying to see what others have done, but at least we saw what they did. But the UK, they had the Insolvency Act, they had the Enterprise Act. So they have a more matured system, right? They have administration, CVAs. They now have restructuring plans. There's various decisions that has given guidance on what should be done, especially what they call cross cram down with dissenting um, um, dissenting creditors, right? Hold out creditors. And then South Africa, obviously, they have the business rescue framework, which has been on, I think, since 2011 or so. And it's a more matured climb. And I think it's not really so bad for us, right? Because what we've now had is the benefit of these jurisdictions, the benefit of authorities in these jurisdictions, and the benefit of the framework, right? Whether from a legal standpoint, from a financial advisory standpoint, from a financial market standpoint, because in London, for instance, there's a deep distressed trading, market there open for people. So I think how we compare, perhaps this is not it won't be fair to ask that kind of question because we're just coming up, but give us 10 years. I trust Nigeria. I trust that we will be able to take the benefit of these things and we would have matured in terms of not just the jurisprudence, but also the business around it.
It's a good thing we've talked about, what's going on in other jurisdictions regarding their frameworks, because I would want to know about cross-border restructurings, right? Because Nigerian businesses, we now see situations whereby Nigerian businesses have operations, in other countries. And we also see where we have international investors bringing money to fund Nigerian businesses. So how do we work around that?
Honestly, that's one area that we still have an issue. There's the residual model law when it comes to cross-border insolvency. That hasn't unfortunately been adopted in Nigeria. So there isn't really that robust cross-border insolvency framework available yet in Nigeria. And it's quite important because as you rightly identified, businesses now go out of Nigeria, have, banks, you have companies, and these are good things into that Nigerian businesses going places, right? They are going to other other countries within the continent and outside the continent. But it comes with its risk, right? You want to have a means of supporting them from a legal perspective, and that is what the Austrian model law would have done if we have adopted it. So we're still championing for that. We're still clamoring for that. We're still providing the advocacy behind it to get the authorities to then adopt the model law. We think it will be good, right? Especially within the context of cross-border insolvency, so that you don't do parallel proceedings.
True. So now that we've established where we are as a country, let's talk about where we are going. What needs to change for Nigeria's restructuring practice to mature? Are we speaking to having specialized court systems, capacity building, having a holistic framework? What, in your opinion, needs to come in? What should we look out for?
I'm not a big fan of specialized court system. Then what typically happens is that, corruption, there should be a specialized court. This specialized court. Maybe tomorrow somebody will probably want to sell tomatoes and then they will want a specialized court for that. So I'm not a big fan of it. We have a federal high court, right? I think it's just about a docketing system, right? There should be designated. I think it happens with EFCC, that's Economic and Financial Crimes. They have judges who are designated that, or family courts also. So there should be judges who are trained, because as you can imagine, corporate restructuring there's a legal aspect to it. But there's also you need to properly understand commerce, you need to understand business, you need to have good finance. You need to be able to read balance sheet.
Having a commercial
exactly, right? You need to be able to read balance sheet at the barest minimum as a judge, right? So I think for me, I don't think it's a question of having this. Obviously, one thing that has to improve is the quality of our judges. We have very fantastic judges, but this is an aspect that is new. It requires training, it requires exposure, it requires interest. So I think for me, if you ask, it would be to have a system where there's a special docketing system. Luckily, there's now an insolvency unit at the Federal High Court where you can actually file how I approach it is another thing. But in theory, you could file and then it will go to judges that are deemed to understand the subject matter. But by and large, what one would look at would be an improvement in the level of awareness, in the need for the justice system, for the judiciary to support restructuring processes, to guard, because the truth is that it is decisions that are made at this early stage that would determine how the Nigerian jurisprudence will be when it comes to restructuring in years to come. And like I said, it is inevitable that we would have a restructuring-driven society as opposed to a liquidation, a debt recovery-driven society. Another thing which I've mentioned, obviously, is the ancestral model. We need that, right? Especially as Nigerian businesses are going cross-border, as we are also involved in cross-border trade with other companies, coming into Nigeria. We need to be able to have a robust cross-border insolvency framework, which the ancestral model law provides. So that is one thing which, needs to change. Obviously, improvements needs to be made in terms of the law from the experiences that we've had over the past 5 years. We are trying to work on it. The committee that I had, we're trying to put together things. The quality of the practitioners also needs to change. And I say this from experience, right? In fact, just today I was saying something in a court regarding one of the restructuring. And I said to myself that it appears to me that some of the restructurings are going well, trying to get creditors to get paid quickly, because that's one thing which I need to emphasize. Restructuring gets you paid quickly. So you don't have to then be in court for years. It gets you paid quickly in a more organized manner. But it appeared to me that most of them, where you have advisors, some maybe legal advisors, you don't want to say that. It's actually the ones that are problematic, and it comes from the quality of the practitioners. They don't understand it. So there has to be awareness, training awareness as to some of the philosophies, right, behind some of these things. The jurisprudence from a legal perspective behind these things. The jurisprudence from a commercial perspective, because it's actually commerce that drives the law. If the law drags commerce back, if law drags business back, then it becomes a law that people would not want to obey, right? So all these things needs to be understood from this. Yeah.
How about having an active distress markets, right? Because we both know for a fact that there are other jurisdictions whereby there are, active buyers of distressed debts to provide liquidity to these companies.
In fact, thank you very much. That's a very important point. Because the truth of the matter is that you can't actually, and also that's it's a very important point that you mentioned. You can't actually do restructuring without money. A company is distressed, right? The first thing you want to do is just like a human being, you want to stabilize it. You want to give it whatever it is, painkillers, it's the body to stabilize for a while. So you need money, right? And we don't have a distress. With due respect to our capital markets or financial markets, I don't think we have a deep financial market, not to talk about a distress market. I think it's not in existence at the moment. So that needs to be done because it needs to support. We need to have a deep financing, a debtor imposition financing, or a new money regime, a new money market where people are able to bring in money into, or even trade in distressed assets, especially where you have such special situations. The problem obviously is not that perhaps people are not looking at it also, but also the legal framework. We don't have super senior credit status for people who are bringing in new money. I'm involved in a transaction where that was one of the questions which was asked. And perhaps maybe now through courts we'll be able to engineer an innovative way of bringing that, because nobody who is bringing in new money will want to bring in new money and have the same, it doesn't happen anywhere in the world, on the same status as the legacy creditors. So you need to be able to assure the person that he will have super senior credit status. Obviously, we don't have those provisions under Nigerian law. So those are things that one would typically want to look at, but you're quite right? Would need deep distressed finance.
Which is very active.
Yes.
Well, if you had to, make a prediction, where do you think the Nigerian restructuring market would be
I
in another, let me say, 10 years?
I think I've done that. I think maybe I jumped. I think it's inevitable that we'll get a more robust market, right? The economics says that the legal framework is there. It will continue to be improved. I think once that is done, we'll be able to get that. We'll be able to get to the finish line. We'll continue improving.
So we've covered a lot of ground today. We've talked about the legal framework, advisory landscape. But before we go, what is one thing that you want to leave our listeners with, a key takeaway from all the conversations you've had?
Whether you're a creditor, whether you're the company itself, whether you're a lender, whatever it is, the truth of the matter is that restructuring is the way to go. It's faster, it's more organized. Well, if you're a creditor, you get paid quicker. If you're a company, it gives you respite in order to be able to restructure. So I think at the end of the day, what I would tell anybody listening to this is turn around that restructuring is the way to go, right? Talk to people who understand the practice and then see how things will blossom for you.
Amala, thank you so much. This has been an excellent overview of where Nigeria's restructuring is today and, of course, where we are going. And to our listeners, thank you so much for joining us today. If this series has been valuable to you, please do all to share with your colleagues who might benefit from it. We look forward to seeing you in the next episode.